his understanding of the meeting. What I will speak about my vote first. I'm a process-oriented guy, and it has to be a very solid exception that would benefit certain things before I say I agree with that exceptions. When looking at the information that you all have worked very hard to put together and your recommendation, and based on asking a couple of questions from Director Siegel, I did not see any benefit of excluding middle housing or affordable housing from the requirement. And especially when the neighborhood chair committees unanimously come forward and say, this is not something that's good for the neighborhood. And from what I understand, there hasn't really been any affordable housing or middle housing that we have on the table that would have a benefit using or a con of not using this exception. So that was my thinking. And I know that Councillor Corrigan was talking about this very specific example that was part of the package or part of the presentation, where that exception, if it ended up being part of affordable housing or middle housing, it would have created a challenge or a issue or a conflict with the neighbor to that property. So looking at the big picture, also Councillor Rapp was thinking that we need to be consistent with our requirements. So all of that, I think that came to the conclusion that at least 5 of us thought we needed to be consistent, and 2 of us thought that those exceptions should be included in the ordinance. Did I answer your question?
Yeah, thank you, Councillor. Again, I think it's always concerning when you have the Plan Commission's recommendation and you have a staff recommendation, and when council goes opposite of that, I think it's very useful for the Plan Commission to understand what the reasoning and rationale for that was. But I appreciate your comments. Thank you.
So more than anything, it was to be consistent with this piece of work. Would you agree?
Yes, that's correct.
Thank you. Anyone else have questions for Commissioner Afghan? Councillor Afghan?
Chair Lee, I also have to say that I don't know if you watched or attended the meeting. We talked about if we need to create an incentive for middle housing or affordable housing, then is this the only place we could do it, or there are other places that we could provide incentive for them? So it wasn't that we wanted to go against you. It was trying to be consistent and figure out where we can incentivize these middle housing and affordable housing. Director Siegel, is there anything I missed or anything you would like to add?
Thank you, Councillor. I think you've captured it. I think that one of the other takeaways I got from the meeting was that it may be premature to consider this very specific exception or these exceptions, that we are preparing a housing production strategy over the next year or so, and that perhaps would be a more appropriate time to look at a more comprehensive solution. So I think it was both, for some council members, and I don't want to speak for them, I think it was the policy. For others, I think it was more about timing and comprehensiveness. Thank you.
Good addition. Thank you. Very good addition.
Is there anything further? Seeing not, let's move on to public comments regarding issues not on the agenda. Do we have anyone who would like to speak?
None.
Okay, thank you. In regards to Commission for Citizen Involvement updates, we have the Westridge Neighborhood Association General Meeting, Tuesday, March 7th at 7:00 p.m. at the Westridge Elementary School. Further, we now have a public hearing on the comprehensive plan map and zoning map amendments to 1710 South Shore Boulevard, LU 22-0058, and public testimony is accepted. Do we have people who would like to testify this evening? Yes.
And Madam Chair, I'll read the hearing procedure if you wish. The public hearing process will be as follows. The first will be a presentation by staff, then testimony by the applicant up to 20 minutes. And I guess I should remind the Commission, this is a quasi-judicial proceeding as opposed to legislative, thus a very structured process. Testimony by parties in support of the application, followed by testimony by parties opposed to the application, and finally testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes. Any person in attendance may cede his or her time for testimony to another person, except to the applicant. But in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Those time limits do not include time spent responding to questions from the Commission. Testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. It is assumed the person is testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they're representing. After testimony in favor, opposed, and neither for nor against, then applicant's rebuttal, up to 5 minutes. And following that would be Commission deliberation, including a statement to the applicant by the Commission of any proposed condition of approval different than contained in the staff report, and the applicant's response to the conditions of approval proposed following Commission deliberation. As stated in the public notice, the deadline for submission of written materials is noon today. No written materials may be submitted to the Commission tonight. Any person may request an opportunity to present additional evidence by requesting a continuation of the public hearing. This land use request is considered to be based upon the applicable criteria and standards. The staff report lists the criteria from the Lake Oswego Comprehensive Plan, Metro Code, LCDC goals, ORS Chapter 197, other applicable state statutes and administrative rules that staff has identified as applicable to the request. It is available online from the Planning Department. We ask persons testifying to please identify to the Commission the criteria or standards you're addressing so the Commission may consider the testimony in relation to the criteria or standards. If you do not identify the criteria or standards you're addressing, the Commission is not obliged to guess which standards or criteria you're testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the Commission and the parties an opportunity to respond to the issue precludes raising the issue to the City Council and the Oregon Land Use Board of Appeals based on that issue. The failure of the applicant to raise any constitutional or other issues relating to proposed conditions of approval with specificity to allow the Commission to respond to the issue precludes an action for damages in circuit court. At this point, I would ask the Commission members to please declare if you've had any ex parte contacts, including a site visit, if you have any bias on the application, and any financial conflicts of interest to declare, starting with Commissioner Rigby.
None.
None. None of the above.
Likewise, none.
I've had no ex parte contacts. Site visits, I'd just like to call out that I believe on July 15th of 2017, and that's prior to the actual application submittal, that the Plan Commission did hold a neighborhood tour of the South Shore neighborhood. And during that tour, we actually looked at the property that's being reviewed tonight for a change in zoning. However, after, that was before the application in several years ago. Since then, I do kind of ride my bike almost every day by that area, so I see it a lot. And I do think about kind of why that land's been vacant and kind of our, history with the tour. I have no bias and no financial conflicts.
No. Thank you. Is there any challenge to Commissioner's right to consider the application? Seeing none, then Associate Planner Paul Espe with the staff report.
Thank you, Evan. Chair Leak, members of the Commission, we have before us this evening an amendment of the comprehensive plan and zoning map from R5 to R7.5 for a total of 4 parcels. consisting of 0.79 acres. The purpose of the application is to change the comprehensive plan map designation and zoning from R5 with an attached condition back to R7.5 without that condition. In their narrative, the applicant states that they explored the possibility of retaining the R5 zoning and seeking an amendment to the previous zone change to remove the condition requiring the development to comply with the previous DR application LU 010005. And the applicant does not wish to pursue that option, as far as we understand at this point, proposing to restore the zoning of the site to its pre-LU 01004 zoning of R7.5. Notices to interested parties, neighborhood associations, surrounding neighbors were sent out on January 23rd, and the notice for public hearing was also physically posted on that date. Unfortunately, the staff report incorrectly indicates that the notices were mailed on February 1st. And we find that only the notice to the Bay South Shore was sent out on that date. We'll make the appropriate corrections to the staff report. The parcels are located on the southwest corner of McVeigh Avenue and South Shore. A portion of Patton Street was vacated in 2009. We'll get into that a little bit later. The approved vacation increased the size of the site from 0.63 acres to 0.79 acres, although the increased area is subject to a pathway easement and utility easements. The site has a comprehensive plan designation of R5 and a zoning designation of R5, which has a condition of approval upon it, as we discussed. Under existing land use designation of R5, up to 6 lots and 6 townhouse parcels could be created. And under the proposed R7.5 designation, up to 4 parcels could be created. Single-family dwelling and middle housing of up to 16 units could also be created under the middle housing standards. And the staff report indicates that 6 parcels could be created in the R7.5, but it really should just be 4.
Excuse me, could you get your microphone a little closer to you? Thank you.
Absolutely, yeah. Sorry about that. Staff could make the appropriate revisions here and elsewhere in the staff report where it occurs. The site is currently vacant and there are no permanent structures on the property, although there are several large trees on the property. Lost Dog Creek is located along the eastern boundary of the site, and this is designated as an RP resource, a RP riparian corridor. As far as the land use history goes, the applicant applied for a zoning and comprehensive plan map amendment to rezone the property from R7.5 to R5 medium density residential. On July 23rd, 2001, the Planning Commission recommended denial to the City Council, and the City Council remanded the application back to the Planning Commission to allow the applicant to submit additional information for that zone change. In order to provide assurances regarding the nature and the scope of the future development on the site, the PC recommended that the applicant file a land use application with the Development Review Commission, or DRC, for the development of a 6-lot townhome development. The development expired in 2003 or 2004, and the related conditions of approval to the DR application are no longer applicable. However, the conditions of approval to the zone change are. On September 23rd, 2002, PC recommended denial of the proposed amendments to the comprehensive plan and zoning maps for the second time. On October 15th, 2002, the council approved the proposed map amendments, subject to the following condition: that the zone change from R7.5 to R5 was thus conditioned that the development of the property was limited to the specific development approval of LU 01005, including the requirements to vacate the abutting portions of Patton Street and Madrona Drive. The applicant obtained consent to vacate Patton Street, but was unable to gain consent for the vacation of Madrona. If the applicant wanted to move forward for the development of the site, they would have needed to file a new application that would include a plan for development of the site that did not require the vacation of Madrona, and a modification for the approved zone change in LU 01004 to remove the rezone condition in the R5. And the applicant to date has not filed that application. Staff finds that the proposed, as far as the criteria for the map amendments, staff finds that the proposed comprehensive plan and zoning map amendments are consistent with the comprehensive plan policies, Metro Urban Growth Management Functional Plan, Housing Rule, and Transportation Planning Rule, and City Code. The standard R7.5 zone allows a little more than 5 parcels per acre, but less than 6. And in this case, for a 0.79 acre parcel, 4 lots could be created, if you ignore the yields that are allowed through middle housing, of course. With regards to traffic, although the proposed zone change back from R5 conditional to R7.5 would likely result in a greater density as compared to the R5 conditioned zone, the additional traffic generated by the R7.5 development, even at its maximum ministerial development level of 16 units of middle housing, would not have adverse traffic impacts. The applicant's supplemental memo addressing traffic impacts states that if the site were developed with 6 townhomes per LU 01005, consistent with the assumptions of the 2013 comprehensive plan, it would generate 58 average daily trips and 5 peak hour trips during the PM peak hour when calculating using the ITE trip generation manual, the 11th edition. The supplemental memo provided by the applicant states that based on trip generation estimates in the table, or Table 1, that the proposed zone map amendment results in a potential trip generation decrease from what is currently allowed in the R5 zone designation. The LOC criteria regarding traffic impact study are not met, and OAR-TRP criteria are met because the amendment will not significantly affect the existing or planned transportation facility. Memo further states that regardless of the development assumptions made in the current R5 zone, the total average daily and PM peak hour trip generation in the R7.5 zone designation is less than the LOS criteria requiring a traffic impact study. Moreover, the trip generation resulting from a reasonable worst case in the R7.5 zone of 9 peak hour trips is considered de minimis and will not significantly affect the transportation system. The city's traffic engineer also agrees and further states that regardless of whether the site is analyzed based on the 6 townhomes approved under LU 01005 or if it's analyzed assuming the no development scenario, it would not exceed our 250 average daily trip or 25 peak hour trip threshold for triggering a traffic impact study required under LOC 5007003. And therefore, we find that the traffic portion of the report analysis has also been met. And based on the information presented in the report, staff recommends approval of the amendments to the comprehensive plan map and zoning map amendment in attachment B of Exhibit A1, and staff recommends that the Planning Commission recommend approval to the City Council. I am open for any questions you might have.
Thank you. Commissioner Stewart?
Will you summarize why the Planning Commission initially denied the application twice back in 2001 and 2002?
I believe that there was quite a lot of public involvement in that particular project, and they didn't want to necessarily have the amount of density that the R5 zoning designation provided. I think it was the main reason.
But wasn't the application though for a zone change, or?
It was for a zone change from R7.5 to R5.
Oh, I see. Okay. My second question is, are there 4 lots, like 4 separate lots on this property?
There are currently 4 separate lots on the parcel. That's correct.
Okay.
And how would the units be configured on those 4 separate lots? Would they aggregate those lots so it would become one lot of record?
They were actually zero lot line townhome, it was a zero lot line townhome development under a PD development scenario.
Yeah, so I guess, yeah, that was going to be my last question. In a scenario where a development application happens, would these lots have to be consolidated to one lot for that to happen?
No, the lots were in their configuration for the PD development for the townhomes, and they would, I believe they were going to have 2 townhomes on each lot for a total of 6.
Thanks.
But there's 4 lots.
I'm sorry, they were going to have 6 townhomes, and I think they were going to have 2 on one lot, or 2 on a few 2 of the lots, and then 1 on each lot thereafter.
Oh, okay, thank you.
It was a while ago, I'm sorry.
Okay, Commissioner Rigby?
Could you go over why the Development Review Commission conditioned the application as they did originally?
Well, are you asking for normally, the Development Review Commission will condition a land use approval, and they'll provide a variety of different conditions. I think the unusual situation that we have before us here is the fact that a zone change from R7.5 to R5 was conditioned on a very specific development scenario that the Development Review Commission approved. And so that's where the problem arose with this, because the applicant was unable to execute that particular development review application because they were unable to vacate Madrona, which required a critical amount of land area to build the townhome development that was approved by the DRC.
So the need to vacate it was to open up more space?
Correct.
Commissioner Stewart?
If a zone change happens, do each of the 4 lots individually become R7.5 lots?
Yes, the zone change will apply to the entire area.
So there'd be
to the
4
entire property.
R7.5
So there will be 4 lots designated R7.5, yes.
Thanks.
Any other questions? Do you want us to make a motion to approve this?
The next would be testimony by the
Right.
applicant.
Okay, do we have testimony for,
The applicant is represented, I believe.
could your notebook be any bigger?
The stuff in it, but I don't think we need to spend a lot of time. My name is Wendy Killington. I'm a lawyer, and I'm representing Jeff Prince, who's with me here in the audience. He is the applicant. And I think staff did a tremendous job of explaining the situation, so I don't want to belabor anything. Just a couple of points. In the beginning, there were 4 lots that were created as a part of an old subdivision. They will remain discrete lots until they're vacated or changed at some point in the future. And they were originally, for purposes of our memories, zoned R7.5. The applicant sought a zone change many, many moons ago to R5. And as you've heard, that R5 zone change was approved, but it was conditioned on basically getting people's agreement to vacate a road who vehemently opposed the R5 zone change. I mean, you're not going to get that. And so for whatever reason, that R5 zone was conditioned on an impossible thing. And so a perfectly good parcel of land that's in your buildable lands inventory that's supposed to be delivering housing to you has been unable to do that. And so the purpose of this proposed amendment, zone change, is to restore the R7.5 zoning district and allow the property to be developed consistently with the city's codes. The only comments that you've received is a comment from a neighbor who supports the proposal that's in your application or materials packet. So far as we know, there isn't any opposition, and so we would simply support staff in their recommendation of approval and ask for your recommendation of approval as well. If you have any questions, here I am. Otherwise, I don't need to take your time.
Commissioner Heap?
A couple of questions is, one, we saw in the staff report that up to 16 units could actually be in that lot. Has the applicant considered 16 units on that lot, and how would that be achieved if they have?
I have no idea. I saw that as well, and I thought, wow, I wonder how that can happen. The applicant is not interested in developing the property, and he'll be selling it. So I don't think he has an idea about how it would ultimately be developed if the city ministerially allows, 16 lots. I guess that's what's going to happen. It's just hard for me to imagine what that looks like there.
But I think what staff theorized was you're looking at middle housing, so you could have a quadplex on there, on each lot.
Like a cottage cluster.
Totally, or a cottage cluster, totally theoretical.
Right. Maybe another question is, does the applicant have any feedback on just the process of, conditionally approving? I know that created kind of the core of the issue at the first approval. Now it's coming back. I mean, does the applicant feel strongly that there should be no conditions of approval, or they'd rather have either a yes, no on the approval? I'm just wondering if there's any feedback on that.
Yeah, that's a good question, Commissioner Heap. I think it's really unusual for a plan amendment or a zone change to be conditioned for exactly this reason. The idea is, you're changing it to a zone that will allow subsequently a particular development proposal to be advanced, and then the impacts of that particular proposal will be analyzed, and then the development proposal will be subject to conditions of approval. It's really unusual. We don't see it very often, almost never, where a zone change will actually be conditioned because of this kind of thing. I mean, things change, or it ends up being that some condition of approval is impossible. So I think the lesson learned is that what is normative in the world of Oregon land use planning probably is normative for a good reason. And that before we do something fancy-pantsy like a condition zone change, we got to think long and hard about it. It's not a very good idea.
Commissioner Rigby?
Is there any reason to believe that a future development that would make this parcel profitable would not be similar or incur the same sorts of problems that the last one did?
There won't be any condition of approval that says that you have to vacate Madrona. And that was the only condition that was impossible here. And in order to vacate a public street, adjoining landowners on either side have to consent. And the person who supports this zone change was one of the property owners who said, no, I'm not going to agree to Madrona being vacated. And so, no, we don't expect any of the similar kinds of problems. Actually, we think we are singing in harmony with our neighbors and the neighborhood association as well for this.
Well, I think I'm asking a slightly different question. It seems to me that the Development Review Commission imposed that condition for a reason. And it seems to me that that was to open up more space. Would this, going forward, would a future viable development require that same increase in space?
No. No, there's plenty of room to develop the 4 lots that are there. Yeah, so no.
Thank you.
Yeah.
Well, and I guess I would just add, I mean, that would be addressed in a development application as to whether, they could ask for it, whether they get it or not, or vacation, that's another matter, so.
So that's
not really before.
That would be addressed in the development review.
We're not looking at the development application here, so it's just strictly a question of whether these lots should be rezoned. And if the property owner at some point in the future wishes to seek that, that's up to them.
Well, it seems to me that the last time this happened, the Planning Commission put it over to the Development Review Commission to look at that first.
Well, there was, the Planning Commission wanted to see a specific development proposal on how would we develop as R5, considering I think that was not consistent with the neighborhoods immediately surrounding it, so they wanted to see how that actually played out.
All of the property around this is zoned R75, so that concern doesn't really apply.
Right.
Anyone else have questions for Commissioner Stewart?
Thank you for your presentation. I have a question for staff, though, real quick. For the R7.5 zone, what is the minimum lot size?
7,500 square feet.
Okay.
Thank you very much for your presentation.
Thank you.
Any other discussion, commissioners, you would like to point out or?
You'd call next if there's
William?
anybody wish to testify in favor, opposed, neither for nor against, before we proceed to deliberation.
Okay. Do we have a motion?
Is there any person who wishes to testify in favor of the application?
Oh,
No, opposed to the application, neither for nor against the application.
then let's hear it.
Bingo.
My name's Edward Conrad, and excuse me, I've got to get next to the microphone here. I live in First Edition. I came down here not really knowing what, I knew I wasn't really for or against, and I wasn't really sure of what portion I was going to testify against. I think I'm talking about the traffic. Within the last week, I saw a term in the Lake Oswego Review that was sort of offensive to me. When I grew up, as many of you do, terms that didn't used to be offensive have now become offensive. And the term that I found offensive was one that referenced Lake Ridge High School and the idea of more parking. And the Lake Ridge and Lake Oswego High School, to a lesser extent, suffers from the fact that Lake Ridge, anyway, is in an area that is a dendritic traffic pattern. That is, it's a tree. The only way to really efficiently get from one part of the tree to the other is to go down the trunks. And any bicyclist knows that you really have to go on the main, they're like, we're in a nice area here. You don't have to go down A Street. You can go down any street you choose. But in the Lake Ridge area, you have to go down the trunks. And two of the major trunks are South Shore and McVeigh/Stafford. And this property is in that area. And in particular, as I look at the map, and I don't know if this is water under the bridge, it can't be changed, but, and I know that the city is putting a lot of effort into, and God bless them, I hope they do a good job. I can't imagine how they're going to do it, but to make a safe bicycle route out of McVeigh-Stafford, a safe route. I think you'd be silly to go certain directions on that street. You can't do it. You can't go on the, I don't think, on the south side of South Shore with a bike. That would be not safe. So the city does have a commitment to make these safe routes to school, and this property may be important for that. I don't know. In particular, that easement may be. The engineers and the staff have to decide, and maybe that easement would be important for turning from South Shore onto the redeveloped McVeigh-Stafford. So I guess that's my only comment, to avoid more parking. One solution would be more public transportation or bicycles. You're not going to have safe bicycles the way things are now. It's just not going to happen. It's going to be a long road, literally, but this may be a part of that, and the staff may have a better opinion on that. I don't know how their plans are for McVeigh-Stafford and whether this property has anything to do with it, but I don't want the city to paint itself into a corner and not have a resource that they may wish they had in the future. That's it. Thank you.
Thank you. It really is a conundrum, having more housing in a confined space and then safe roads for biking, isn't it?
It is. It's beyond my capabilities.
Yes,
and
almost
again,
beyond everybody's
when the staff said that they were going to develop McVeigh-Stafford for a safe route, I just can't imagine that. But I'm not doubting them. I just can't imagine it myself. But it's a tough thing. Very tough.
We have a question from Commissioner Heap.
Yeah, first, thank you for giving your testimony tonight and the interest of the public. I really appreciate it. As we heard from the Deputy Attorney tonight, what we as the Commission are looking at is, has the applicant met the criteria, are all the criteria met? And so I thought it was very interesting, the testimony you're giving, but I was just wondering, can you tie it to a particular criteria that the Plan Commission should be evaluating?
The part on traffic.
Otherwise, we may not be able to.
Well, exactly.
Yeah.
I was struggling. I appreciate Mr. Boone's comment. I said, oh my gosh, I got to tie it in. Well, I tie it into the traffic. I don't, traffic, a lot of people, I don't think you, but a lot of people say traffic is automobiles, but it's beyond that. So that's my tie-in. I think the city needs to reconsider the traffic aspects.
Thank you.
Thank you very much.
Okay,
Appreciate
thank
your
you.
testimony.
All right, next up would be the applicant. Do you wish to have any rebuttal? No. Okay, pardon me 1 minute. All right, prior to closing the public hearing, any person may request an opportunity to present additional evidence. If a request is made, the public hearing will be either continued to date certain, not less than 7 days later, or the record shall remain open for at least 7 days after the hearing to enable additional written evidence or testimony to be submitted, and the commission would establish the period for any rebuttal written evidence to be submitted. Is there any such request? And see, the gentleman has left and the applicant does not. Does the applicant wish to submit final written argument? No. You may proceed to deliberation, Madam Chair.
Thank you very much. Anyone want to discuss moving forward with this? Commissioner Heap?
Yeah, just I'll share some of my thoughts on the testimony we heard tonight. If again, I think the job of the commission here is to go through and look at the specific criteria and ask the question, has the applicant met the burden of evidence to say that the criteria has been met, yes or no? And so I did appreciate the testimony that we just heard from the gentleman earlier about traffic. From traffic, I really had no issues with that. I think, the trip analysis that was done by the city's engineering staff and the applicant's narrative was okay. But I do appreciate the testimony and the overall concern of the community and bicycle, but I think that criteria has been met. The other criteria too, regarding to, the city services, is there water, is there sewer? I really didn't see any issues with that either. So I thought the criteria has been met. And then there was some discussion from commissioners tonight about a little bit of the history, I think, of the earlier decisions. And, I too was going back and looking at that and trying to, look at the zone and could it meet kind of our overall comprehensive plan and city goals. And at that time, looking at it, and if you wanted to do, 6 townhomes in there, then as the commission was saying, the only way to make that work is you got to find space. So, you're looking at vacating, I think it was the Patton Street, you're looking at vacating Madrona Drive, and then you can open it up. And then furthermore, you start doing zero lot line type of dwelling. So you're packing the townhomes together. And so, at R5, you can get 6 times 5, 30,000 square feet, which just fits in there. So, from that, it's a packing perspective, and it makes sense for situating that. So then the only concern that I had is if we go to policy E1, A through G, this says that we ensure the amendments to the comprehensive plan map and the zoning map are subject to specific locational criteria and other standards, including conformance with the comprehensive plan goals, the effect on the overall land supply and metro housing rule, OAR 660-07-00. And as we heard tonight, if you look at 16 theoretical dwelling units on the property, well, that is theoretical. You're not going to get it. And so for me, what I really see happening here is a down zone. So, we're moving from a higher intensity use at the R5 into the R7.5, I think the applicant did a great job at trying to describe, now that we have middle housing and you can do these additional units, how you can actually increase the intensity, even though you're going up to an R7.5 from an R5. So that's kind of interesting. But then if you go back to the practical matter, then it just seems like we're doing a down zone. And so then that criteria of really, policy E1, A to G, ensuring that the amendments to the comprehensive plan map and zoning map are subject to specific locational criteria and other standards, including, D, E, and F listed in that section, like the metro housing rule. I think we're not, or the intent of this is not following this. It's a down zone, which is going against that. And so one thing I know that we've discussed in the commission is, and again, we heard from the applicant, is not favorably looked upon as conditional approvals. So I would say if there was an actual condition to say that the number of dwelling units would remain the same as under the current R5 zoning, then, I would be okay. I don't see that criteria being violated, but I don't think anybody wants to do conditional approval like that. So, my position would see that criteria hasn't been met, and I wouldn't be in favor of approving.
Thank you very much. Commissioner Stewart?
So I think sort of my path of questioning is intended to lead to a concern just looking at this. I mean, unless I'm missing something, two of these lots can't be our 7.5, right? Because they're smaller. They're not 7,500 square feet. So how would we be able to zone those 7.5?
They'd be non-conforming to the zone. We have a number of, the whole Hallinan neighborhood has 5,000 square foot lots, and it's zoned R75. So those.
But were those pre-existing though, or?
Those are pre-existing lots, just like this underlying. The legal lots of record are created.
Right. But I mean, can we create non-conforming lots though?
Yes.
Okay.
Yes, we do that many times, not just on the R75 issue, but when when additional development standards, dimensional standards are created that can create non-conformities to the existing residences that are already there. In this case, there's no residence there, so the non-conformity is the lot area.
And also that's going back to the original zone of R7.5.
No, I understand that. I guess all right. I wasn't aware, I guess, that you could create a lot that doesn't meet the minimum size.
Yeah. There's no prohibition against creating a zone on it that doesn't meet the lot area of the underlying lot. The lot area doesn't meet the underlying lot. The definition of nonconformity is that a lot which was conforming at one time has had the rules changed. Okay? It's just nonconforming, that's all, and then it has to go through some nonconforming restrictions on development.
Okay.
Thank you. Commissioner Heap, you want to speak again?
Oh, yes, I was just going to follow on to Vice Chair Stewart's comments. I was thinking kind of similar thoughts like that, but realistically, what I would see happen would be that, it would probably be partitioned differently. It'd probably be divided up into 4 lots of our 7.5 that would.
The question of whether it was going to be consolidated or read.
And I know that's a development application type of question that wouldn't be here.
Right.
But realistically, that's the way it would work. And again, I think that's where it comes in where I have a problem with, is it really following the goals that we have in the comprehensive plan and the ORA 660 statute that, I would see it be more for single-family homes on R75 that were, compliant with our 7.5 zoning, and that there's no way there's 16 units that are going to go on that parcel or those 4 parcels now. But, would there be some opportunity for, some additional dwelling units in terms of, duplexes, whatever it is, to bring it up to 6. And then if that was the case, I would be okay with it, because we're not really changing, we're not doing a down zone. We're keeping basically the intensity the same.
Thank you, Commissioner Heath. Commissioner Rigby?
I find it difficult to find that, as under E1F, that there's a demonstration of public need for this change. The reasoning for it seems to be to allow the kind of development that was allowed before with conditions, and this would simply get rid of the conditions. So I don't see any change that would that is needed by the public for this, and I think conversely that a change would create more incompatibility with the local character.
Thank you, Commissioner Rigby. I would just like to say that I feel that this should be approved. The intent is to build attached units that would provide more density and more housing. And the way they end up doing it will be up to them. And this achieves a goal that the city is mandated and wants to see. I think your comments are all well placed, but you're splitting hairs. And the final goal is to get more housing in the city of Lake Oswego. And therefore, I feel strongly we should approve this. Seeing, no, Commissioner Stewart.
I think after my discussion with Mr. Boone, I would agree with you. As an architect, and I'm reading this sort of thing, my mind immediately goes to, well, how can you do it? How does it fit and all that? Because that's just naturally how I think. But knowing that that's really, how the property ultimately develops is not really what we need to be anticipating or trying to weigh our decision on. It's really about, is the lot or group of lots, can it work for something, right? And is it an appropriate use? And I think that location, it's sort of on the it's on the edge of a neighborhood, but it is
on the edge of
near
commercial.
to, yes, it's near to, I can't say it's
Gas
abutting, but
station.
it's close, well, I guess it is abutting a commercial use. There's commercial uses across McVeigh and within eye shot. So, I think where we really want to develop our multi-housing ultimately are on these sort of fringe sites, because I think that's how cities want to work. So I'm currently in favor.
Thank you. I agree totally. Instead of throwing in roadblocks on systemic or systematic, picking apart item A, B, or D, this fits, and the neighborhood doesn't have any opposition to it. They're in support. The planning department is in support of this. I think it's a no-brainer. Commissioner Rigby?
Well, I think if we look at what our predecessors thought on the Planning Commission and on the Development Review Commission, they looked at this and saw that in order to meet this kind of increase in use, that it would need certain conditions. So to me, this looks like just, keeping the voting going until you get the result you want. And that doesn't jive well to me in terms of the public process.
I would just say, 22 years ago, they were using different rules than we are now. So you need to keep that in mind.
Under different mandates from Metro 22 years ago to do what we need to get done.
Well, if I may ask staff, is there an identifiable difference in rules that they considered?
Well, I would just say in terms of the process for approval of a townhouse unit, it did used to require a development review permit. And as of our middle housing rules being adopted last year, that is no longer the case. So we would not subject a new townhouse development to this type of development review, subject to conditions that were imposed on this 22 years ago or so.
Commissioner Heap?
Just a quick comment to Vice Chair Stewart's. You know, the rules didn't exist. I think the overriding rule here has been the urban growth boundary, and basically the need for communities like Lake Oswego to be very efficient with their land use and do infill. And again, as we talked about earlier, I think the issue was, you know, can you make a zone policy that meets the requirements and does, you know, very efficient infill like that? And so they're trying to, you know, make the most use out of the land, get the most density that they could. And I don't think that's changed. I think what's really driving this, in my opinion, is the urban growth boundary and the requirements that communities like Lake Oswego have to basically do infill and be very efficient with the land.
Thank you very much, Commissioner Heap. Any other comments, additions? I guess at this point, we are done with deliberations, and we should have a motion to move forward with approving this or not. Do I have a motion?
I will move to approve as presented.
I'll second.
We have a motion to approve the comprehensive plan map and zoning map amendments for 1710 South Shore Boulevard, LU 22-0058. Do I have a second?
Second.
Is there any further discussion?
Yeah, thank you.
Go ahead.
Yeah, thank you, Chair Lee. I'd just like to say again, the reason why I'm going to vote no is specifically on policy E1, A to G, and the criteria of, especially on E, the effect of the overall land supply and metro housing rule. I think in effect, this really is a down zone. I feel like in some ways, you know, going from R5 to R7.5 has been enabled through the middle housing rules that we enabled, and that's all in theory. That in practicality, what I would see would probably be the most likely outcome for this would be, you know, 4 very expensive R7.5 homes, you know, in that zone. So I don't see a path that this zone really supports those policies. I see it going against affordable housing and adding more units, increasing the density. So that'll be the reason, specific reasons why I vote no.
Thank you very much. Any other discussion? We have a motion. Do we have a second?
Second.
Okay, all in favor? Call for the roll, please.
Heap,
No?
Leek,
Yes?
Mitchell,
Yes.
Phillips,
Yes, it seems like we're back to where we started 20-plus years ago to me, so I'm okay with it.
Rigby,
No.
Stewart.
Yes.
It looks as though the motion passes. Thank you very much for all the participants.
And a tentative decision, this is a tentative decision with written findings brought back to the commission at its next meeting on February 27th.
Thank you very much. Do we have any other business this evening to discuss? Thank you. Seeing no other business, do we have a schedule review?
We certainly do. All right, so coming up on the 27th of February, our second meeting this month, we have, actually that will be a fully remote meeting, so just a heads up on that. We'll be holding our panel for the psilocybin time, place, and manner regulations, as well as considering the findings for the application for the rezoning that you considered tonight. Coming up on March 13th, we'll have our next work session on the Palisades Mid-Century Overlay. And then coming up on March 27th, we'll have a follow-up work session on psilocybin and potentially somebody in here to speak about the regional transportation plan, though that's still tentative. And that brings us through the end of March.
We have a busy schedule this year, don't we?
There's a lot going on.
Yeah,
That's
there's a
true.
lot of balls in the air. Commissioner, did anyone want to make a comment on this, on the scheduling? Okay, seeing none, I guess we are finished, and I call this meeting to adjournment.